So we're going to hear from Jamaica Lands now. Could you introduce yourself from Jamaica Lands? Hello. What happened?
Oh. Good morning, everyone. I'd like to express my appreciation and thanks for the opportunity to present our submission. My name is Alex Smith. I'm here as the Secretary of Policy Coordination at Jamaica Lands. I'm joined by the First Secretary and Deputy Chair of Jamaica Lands, Ms. Sabrina Medwinter. This submission of ours was based on 7 meetings in January and February 2022. Those meetings were of various sizes, the largest meeting having 11 attendees. So Sabrina will speak more on who we are as Lands and how we function as an organization.
Lands is a political organization that is currently structured as a network of political cadres and community-based clubs that discuss current affairs, national problems, and the problem being faced by people in our communities in order to come up with solutions in a democratic way. We were founded in November 2016 as an effort to consolidate the left. Currently, most of our members and observers are youth, with almost all being born in the late 1990s and 2000s. Over 200 people.
You're going to give us a synopsis.
Okay.
Yeah.
200 people are involved in Lands. Currently, 150 people are active. We had 20 meetings in January of 2022 to discuss this topic, and we had 150 meetings in 2021. All right, so we've sent delegations to international events hosted by different grassroots movements, labor unions, political parties. This is not our first time engaging the government on different bills. We've made submissions before and presentations to Parliament. We've made presentations on the sexual harassment bill that stirred up a debate that ended up impacting the bill. And this motivates us to continue engaging you. We have sent previous submissions on customs, as well as domestic violence.
Go ahead. You can point us to relevant sections of your contribution. Yes. But what we're hoping is that you just highlight the main points.
Okay, thank you. So our submission speaks to 5 broad areas. Lands generally supported the thrust of the Act. There were comments regarding the definitions and forming the Act, Section 2, the range of employee protections in the Act. There are considerations for additional prescribed persons. That refers to the list in the first schedule. Notes on the conditions to qualify for protection, as well as one short comment on the penalty for non-compliance with the designated authority as written in the Act. So I'll begin with an overview of Suggestion 1. Again, that's about the definitions informing the Act in Section 2. We supported some of the definitions and hoped that they remained intact, but there are others that we had particular comments on. The definition of employee, as written in the Act, we found it sufficiently broad. It includes those who work and get paid, assist with or without pay, or who are contract workers, so not within the internal employ of organizations, but contracted for specific tasks. The definition covers all of these possibilities and we suggest the Joint Select Committee not narrow the scope of this definition. Continuing further, there was a list of conditions that would meet improper conduct per the Act, specifically, quote, conduct, the item F, conduct that shows gross mismanagement, impropriety, or misconduct in the carrying out of any activity that involves the use of public funds. Some persons in lands found that this definition could be expanded, and when discussed further, we found that conditions such as the matter of ill-gotten gains or speaking to non-public funds, those would be fair things to expand the scope to. Though we do acknowledge the possible overlap with item A, criminal offense. In that same list in improper conduct, there's item H, quote, conduct that tends to show unfair discrimination on the basis of gender, race, place of origin, social class, color, religion, or political opinion, end quote. We suggested that this definition be augmented, whether that means considering other protected classes or some phrase that speaks to any other status.
Yeah, how would you augment it? I mean,
There was no. If you look to suggestion 1.6 on page 5 of our submission, you'll see reference to the phrase any other status. We initially thought that phrasing was reflected in what we write as a Bill of Rights, what actually is the Charter of Fundamental Rights and Freedoms. We believed that was the case. It's not quite the case, but that was the most common phrasing that came out of further discussions of the Act and our submission. That phrase, any other status.
But just to go a little, sorry, Chair. Just to go a little further, because if you have a rubric of any other status, what could have been another status that could have been considered to be part of that overall rubric of any other status? For example.
So one particular change that could be added, if there is in a legal or juridical sense a distinction between gender and gender identity, having gender identity be enshrined as one of those statuses. In fact, that was another suggestion of ours to possibly supplant gender for gender identity. But if gender is to remain, gender identity being another example. The rest of that suggestion speaks to occupational detriment. We specifically found the definition of occupational detriment in Section 2 to be sufficiently broad, and we suggest that the definition not be reduced. So that is the thrust of suggestion 1 of ours. I'll let my colleague, Ms. Medwinter, continue on to suggestion 2, unless there are further questions or comments from the committee.
I'm not too sure that we are clear what exactly you're proposing. I mean, are you? I mean, I'm not too sure. Yeah.
I think one of the misgivings I have is that I'm not really seeing the justification for some of these suggestions. So you're suggesting this.
Pull the mic a little.
I'm sorry. Yeah. One of my misgivings is that I'm not really seeing the justification for the suggestions you're making. So in order to be persuaded that the suggestions are sound, I would want to hear what the basis of the suggestion is. So for instance, I mean, I don't understand 1.5. That's a suggestion that I thought this Parliament had long settled.
I'll speak to general justifications, but then there was a question I had about your question on 1.5. The phrasing "any other status" allows for the act to protect persons who in practice are deserving of particular social protection, but who we don't consider in a particular moment. So in the past, these lists of protected classes that are listed, gender, race, place of origin, social class, color, religion, or political opinion, in the past, there was clear legal discrimination on these bases, and we've enshrined protections to prevent that. And so it's possible that in future there will be other classes to protect that we consider. Having the phrase "any other status" allows for that inclusion.
You'll allow me. Mr. Smith, you are looking at 2H, section 2H.
Yes.
Right. And you are suggesting that among some of the recommendations that you are suggesting is that, and I'll read, conduct that tend to show unfair discrimination on the basis of gender identity instead of just gender.
One of the concrete suggestions of ours was to replace the phrasing of gender with gender identity. But you could also...
No. So fine. I understand what you're saying.
So that's
but
one.
Read with me. And I'm saying that you're saying on the basis of gender identity instead of just gender. Do you have the legislation in front of you?
I have the act in front of me.
Right. So I'm looking at what 8 says.
Correct.
And you're basically saying that we, on the basis of gender identity, race, place of origin, social class, color, religion, political opinion, or any other
status. To be looking back at our suggestion, I believe it was Senator Gale who asked about other examples.
No, I understand that, but I'm asking you is if you'd like us to substitute, your recommendation is that instead of gender, we have gender identity. That's all I'm asking.
That is one of our suggestions, yes.
And the second one is the last one you alluded to, which was any other status.
That was a broad addition. We did have a specific addition, so I'd just like to address Senator Gale's question. We also called for provisions against unfair discrimination on the basis of mental or physical disability. So that would be an example of a form of discrimination not within the scope of 2H that we felt deserved to be in 2H.
Okay, fine. But what about the any other? That is what I'm a little concerned about. Because you're saying that we are to look in a futuristic way as to what may come along. That's what you're saying, actually.
That's what I'm saying today, yes.
And basically, can you help me? Because I'm somewhat cast in the past as to what future things you may be referring to.
Well, for one thing, mental and physical disabilities. The Disabilities Act is recent legislation, for example, and as I just referred to, we suggested protections for persons from discrimination on the basis of mental and physical disability. So that's one example. That's one concrete example of
would you be satisfied if we just included that alone as part of the committee's deliberation?
That would be closer to, that would be much closer to what the lands-based desires But I would still suggest serious consideration of that phrasing, any other status.
I have a challenge with that, because I am inclined to agree to the suggestion of mental and physical disability. Mm-hmm. The act is reviewed after some time. This is the first, and I'm sure that there will be subsequent considerations at a committee such as this. Mm-hmm. I prefer to cross that bridge when I reach there, But I mean, I cannot, I do agree with the physical and mental disability, but I can't agree to conceptualize something that doesn't exist or is not defined.
Okay, it's fair to say that you wouldn't necessarily want to define get ahead of yourselves in definition, but in terms of non-existence, I would again reference what I said earlier. A number of these discriminations that are specifically referred to in the legislation, at one point in Jamaican history, each of them was considered just fair behavior, nothing to legislate against. And so because they had to be legislated against, sanctioned as discrimination.
But
there may be particular social dynamics that we take for granted that a generation later, or maybe not even a generation later, we consider discrimination. Again, mental and physical disability being an example, since this act was passed in 2011, and I'd say in 2011, even by then, there was a clear, not in necessarily legislation, but clear on-the-ground understanding that discrimination against persons with mental and physical disabilities is a thing.
No, but you will agree, Mr. Smith, that, any other status is too open-ended. I could ask the CPC. CPC, is there anything more embracing? This any other status is just anybody. It doesn't, you need to have some context. CPC, is there any other phrase we could use to assist Mr. Smith?
Difficulty. I agree with the statement that we would need to be specific as to what is being protected.
Exactly, because this is just a right. I don't. You see, Mr. Smith, what we're trying to wrestle with is almost to say anything. When you say any other status, it's almost like saying anything. That doesn't make sense. So you wanted to?
I was really going to offer the thought. This is the Protected Disclosures Act. It's an act to protect whistleblowers in certain circumstances. It is not meant to be an act to deal with discrimination generally. It is a law that we have passed to ensure that certain matters in the workplace, in society, that need to be disclosed can be disclosed, and the person disclosing can be protected from any reprisals. So for that reason, I am not inclined to consider a sort of broad, open-ended amendment to this particular provision. I also reject wholly this idea of prospectively legislating for conduct that I can't imagine. Right. I can't understand the circumstances in which they would happen. I can't conceptualize what scenarios will arise 20, 30 years from now. That is for that generation to address if it arises. But I can't say, if in case, let me put this in now. That just is not how I think legislation works.
Thanks, Member Campbell, Golden. You see, Mr. Smith, at the end of the day, if we agree on any position, the CPC has to put it in context. And as CPC points out, at least there should be some indication of who is to be protected. It can't be any other status. You see the point I'm making, Mr. Smith? In other words, as Senator Campbell Golden is saying, who do you anticipate would need this protection? Most persons are people in a business place, public institution, and 2H, as you can see, try to cover all the persons who could be affected in that institution. But then when you just say any other status, it's just too open-ended. You see the point? So we're not going to, we have to be frank and say, I don't think we can support that position. All right? All right, any other point? Member, any other question you'd like to? Sure, yes.
Yeah, just to clarify, Chair, and I share the sentiment of the committee, but I note from their submission that they said several persons in lands, which mean some have, and I'm not sure how large a majority of lands, because lands itself is also defined in terms of the number of people in it. But how widespread is this group that is asking for us to make legislation that is going to be meaningless?
I don't have the exact answer of how many persons made that specific. I think you're quoting from line 1.5 there. Okay, so I don't have the exact answer on hand as to how many, but what I will say is that there were a number of meetings. There were 7 discussions. There were opportunities among the groups who met. If I have a mental count, it's 4 units, four groups that met, and they, at least 4. And there was an opportunity for cross-discussion of what each group had to say. So it's not that every group came up with every suggestion. It's that specific groups came up with specific suggestions. There were opportunities to discuss those suggestions in other groups, and that this submission forms, as close as possible, a consensus of those groups, of those positions.
You say you have now elevated the sum to consensus. And it strikes me that some members of your group maybe have the same view that the members of this committee seems to be having. And
yeah.
But when you say consensus, you're essentially saying that's not so? That there's no disagreement amongst you, your own group?
This isn't to say that there wasn't disagreement. There was disagreement. It's just that when submitting on, in some submissions we have reflected disagreement. In this case, the language of the submission suggests to me that there was no disagreement so much as difference in emphasis among the groups. So one group found it particularly important to hammer in on the definition of improper conduct, for example. Another group would find it particularly important to speak on penalties for not complying with the designated authority, as another example. So we do have disagreements in our various groups, but we seek a process which resolves those disagreements and leads to outputs that most, if not all, of the base can agree to, such as this submission.
All right. Yes. Go ahead.
Mr. Smith, thank you for making these submissions. You've just started. I want to say that I share the opinion of the committee in terms of the other status, but I would like to thank you for including mental or physical disability which needs clearly to be added to this section. I wanted to express my appreciation for that in particular.
That is noted, and
because we often overlook it. And my friend, Professor Floyd Morris, has made me very sensitive to the need to pay attention to those who have a disability, whether it be mental or otherwise.
We appreciate that support.
Member Guy?
Mr. Smith, I notice on page 5 of your submission, at 1.2, you have definition of employee. Are you suggesting that your group is acceptable of the employee as is indicated in legislation here?
Precisely. In fact, we specifically do not want that definition to be narrowed in scope, perhaps expanded in scope. The expansion wasn't contemplated in meetings, but specifically not narrowing it down. So for example, we found it particularly useful that contract workers were included. The conditions of contract workers is a very close concern of ours, as that becomes more common in the labor market.
Mm-hmm. Okay, thank you, because I was a little concerned as to the issues you have regarding definitions in the Act, which forms part, well, the entire page 5 of 10 were issues that needed correction, you know? Hence my asking the question, but I understand perfectly now.
Mm-hmm. All right, Mr. Smith and your colleague, are there any other identifiable points you would like to raise? Because the point is that many of the points you've raised so far seem to be supporting. You would like the legislation to remain basically intact, even except one or two of the points you're trying to raise. Let me hear the other points.
To give you a summary of the second part, employee protections, which deals with Section 11, disclosure to an attorney, and Section 17, which is occupational detriments. For Section 11, we want it to be expanded to include more affordable options. For example, we wanted it to include disclosures that employees make to industrial dispute tribunals. And then for...
No, go ahead, Member Robinson.
I'm in supportive of the thrust of your argument, which is that it shouldn't be restricted to an attorney because people may not be able to afford it.
The only point, though, I saw that point, you see, Member Robinson, but the reason why I think Section 11 was put there is that any matter between attorneys and their client is privileged. So it is just restating a legal position.
But I think it should be expanded beyond just the attorney. And you have said IDT. I would want to say a member of a trade union.
No, but if you look at it, what I think, remember the Protected Disclosure Act is saying that if you disclose something that happens say, at the workplace, what is disclosed is protected. That's the idea of the Protected Disclosure Act. In other words, you can't suffer a severe consequence or any consequence from disclosing something.
I know, I understand that, Chair, but their point, which I support, is that not every employee will have the resources to engage counsel. So they want to expand that beyond counsel to other persons, and in my view, I would put a member of a trade union who may be representing the workers there. Justice of the peace, possibly.
A minister of religion?
A minister of religion.
just so that it is not restricted only to a lawyer.
But the truth of the matter, though, you know, I get the impression from the Act is that whoever you disclose it to is protected. Right?
Maybe the only difference is that, so 11 is speaking to who you disclose to, in this case, the attorney.
Yeah.
I believe, though, 17 now speaks to the occupational detriment, which is more after the fact, not a protection before, but after the fact. What I hear Member Robinson to be suggesting is that expand somewhere within the provisions, could expand to a medium in which the worker or the employee can report these matters to. Mm-hmm. Whether within the organization where they have some confidence to do so, or externally, but have some other avenues in place that are legislated as a part of a discourse.
Okay.
That's what I'm understanding.
Go ahead.
Mr. Chairman, I understand the submission that is being made, I think. The difficulty I have, though, is that I don't think it has considered the scheme that is currently available under the Act. And I don't know that I necessarily see a reason to expand it beyond what the Act provides, because the protection given to a person making a disclosure to an attorney under Section 11 is, I agree, really not necessary in the Act, no. but it is a sort of overemphasized, perhaps you want to call it a reminding provision, because it already exists in law. What the Act does in terms of protected disclosures, in terms of protecting disclosures, if we look at Section 9, the Act spells out when you make a disclosure to a prescribed person, that disclosure is protected, and the list of prescribed persons under the first schedule is quite vast. Yes. Includes, of course, disclosures to the public defender, the public defender's office that is available to every citizen in the country.
I think we have also included the IC, the Integrity Commission.
The Integrity Commission is one, the DPP is another, the Contractor General, the Commissioner of Police, the Children's Advocate, the Bureau of Standards, the Bank of Jamaica, the Auditor General, the Financial Services Commission, the Independent Commission of Investigations, the Inland Revenue Department, NEPA, OUR, the Political Ombudsman. That office now resides in the Electoral Commission of Jamaica.
The JCF, CISOSA, in other words.
Yeah, so my question then, so that I can better understand what is the rationale behind an addition to this? Because the list can be expanded, and the Act provides for the minister to expand the list. But help me to understand why that particular suggestion.
Because I can tell you, as minister, I expanded it to include the Integrity Commission.
Okay.
And any other body that you think should be included could be recommended to the relevant minister, in this case myself, who could just expand it. You see, what I think is important, and this is what I want to find out from you, Mr. Jamaica Lands, do you think there are wrongdoings which are not exposed because people don't have the necessary avenue to expose them?
Yes.
Right. So are you right?
Mr.
Are
Chairman,
you saying there are some other bodies that persons would have?
Mr. Chairman, hold on a second, because I don't want you to hijack my point till I finish it. The suggestion here is about the trade unions,
Yes.
correct?
Industrial,
The Industrial Disputes Tribunal. But a disclosure to the Industrial Disputes Tribunal would not be an appropriate process in the context of reporting any wrongdoing or improper conduct in the workplace, because the Industrial Disputes Tribunal is a
Like
tribunal that is considering and making a decision about something. They're not a regulating authority. They're not an authority that can stand in protection of a citizen in that way. They are, in fact, what we would call a quasi-judicial body. And so you would not make a disclosure to a judge as the decider of fact and law. You would make a disclosure to an advocate who would bring a matter to the court for the judge to make a determination. You would, in fact, prejudice the IDT if they were the body receiving disclosures. So for that part, I wouldn't support that. I think Member Robinson was suggesting a member of a trade union. I would also have a difficulty with that, because I think it would depend on the context for me, because the trade union or the member of the trade union is very much involved in in other words, they're not an impartial body. They're representing one facet of the workplace issue. So I would have an issue with that as well. But definitely, the IDT, I think, would be a most improper process if we were to allow them to accept disclosures.
Thanks, Senator Sherin. May I just say that what I think is very important, which I asked Jamaica Lands to look at, when you look at the first schedule, as Senator Sherin Golden has pointed out, that there's a list of bodies that any misconduct, wrongdoing in any department a person can disclose to, with the view that action can be taken. You see, now the question I really would like Jamaica Lands, when you get together again, can you think of any other body that, say, a public sector worker or a private sector worker would feel more confident to trust information to? You get me? In other words, right, exactly. I mean, but, sorry.
A note from the schedule.
Right.
That the bodies are commissions of parliament.
Yes.
So they are state actors, the public defender, the commission of parliament. But almost all of them is tied to the consolidated fund one way or another. That's the best way to put it. They're all funded by government. And so the issue of trust arises. And would Lands be of the view that that grouping in the schedule should be extended to include justice of the peace, an officer, ministers of religion, an officer of a trade union, consistent with other legislation. But I agree with you, Senator Golden Campbell. The IDT is adjudicating. It's not for them to be given the disclosure. They come in at the back end when a detrimental action has been taken against somebody. But I'd like to move it, if that's the view of Lands, and whether it's their view or not, to include some non-state actors.
Well, here is it, that they have, by the nature of their submission, they have opened some thought.
Yes.
It might not be the IDT being the right one. Looking on this schedule, these are actors that has the authority in law
to take action.
One of the things we need to do now, because this is a piece of legislation, Chair, that has not been successful in its attempt, and we can ask question of any of these if any report was made to them. Certainly we have the OUR, so we will ask them.
Yeah, I think it's an interesting discussion.
But where I'm going, and you slightly alluded to it, where you may have suggested whether or not we can identify another grouping to which people, or certainly employees in this case, may have a comfort level in approaching.
Absolutely.
They're not actors, you know, they can't act in law, but they can be a recipient to treating with these matters, and the employees would have confidence in going to them, because they might be afraid to go to these, not understanding the level of repercussion or exposure.
Apart from that, a lot of persons don't want to be an informer, but they feel confident in talking to a minister of religion, a justice of the peace,
or a trade unionist.
A trade unionist. In other words, so CPC, is it possible that we could put a category, third-party confident? I mean, a phrase. Third-party confident, that what we would do, you see, is to say that these third-party confident would be the ones who take it to the relevant authority to take action. Because there's no doubt that a lot of employees, a lot of persons don't like to be upfront with their allegation to the person who they know will be taking action. But to the extent that a trusted JP, trade unionist, minister of religion, doctor, who basically can receive the information and can reveal to the relevant authority that can take action, I swear, or I can declare that this person has given this information even without revealing that person's, identity, because they want to complain, say, about the boss and whatever the misconduct the boss is engaged in, but they would like it to go through someone they're confident that can take it to the relevant authority to take action. So you see, CPC, that is where we're just wondering if in the first schedule it could be a disclosure to a third party.
So, Chair, I don't think that the inclusion in the first schedule is appropriate, because those are the state actors who have the duty under Section 18 to carry out an investigation within the scene, where the persons who were named as examples, I don't think have that kind of authority. But perhaps you could consider something similar to the disclosure to employer under Section 7. So rather than disclosing to an employer, for example, the person could be allowed to disclose to a minister of religion, and that person would have the same obligations or similar obligations to what is placed on an employer who receives a disclosure under Section 7. So it would be another category.
Right. So it could be a sort of broader category.
Just for clarity, Ms. Grant, it would have been an expansion of 7B to a C.
A C.
E, D in this nature. Where I'm having the concern is where the consideration of an expanded list. The first schedule has an expanded list that we may expand further.
No, but what CPC is saying, though, Member Gale, is that list are persons in authority who can take action.
Yeah, I understand that. I understand that clearly. But yes, and they act within the confines of their authority.
Right.
Now, this prescribed area now may be of the nature of a listing to which we had made reference to. And I'm just wondering where that would fall.
But CPC is suggesting an expansion of section.
Well, a new section after 7, but it would be similar. Right. And if you like, it could include provision for the minister to prescribe those persons by order.
You see, what CPC is saying is that in that list, apart from what is there in 7 or another section, we are saying that the employee could disclose to the trade union, to a GP, to, you know, and such other person in authority who they trust that can disclose it to one of the person in the first schedule.
Okay.
That's the point. So I think you'll get the point. Lands, what we brought up, which I'm glad you raised the point then. So we are able to look at a possible adjustment to the protected disclosure that would give employees and other persons at the workplace a wider opportunity to disclose to someone they trust, with the understanding that that list to be put in 7 or a subsection of 7 or another section, that that person would be given the trustworthiness of the employee or the complainant to take it to the relevant authority under Schedule 1, under the first schedule, so that they can act on it. Is that okay, member? So, Member Sophia, Dr. Longmore would like to.
Thank you, Chair. Apologies for being late, and I'm just able to wrap my mind around the conversation. But I think what is probably the solution that is being sought likens to when you have a case of abuse. I'm just putting it in my context. When you have a case of, let's say, child abuse, there is an obligation almost when a practitioner recognizes that such is the case to make such report. Mm-hmm. And there seems to be a gap where we are trying to find a solution without the agency that could play that intermediary role, if I'm getting the perspective. Mm-hmm. So what I'm suggesting is, and again, like I said, I'm joining the conversation late, is there an arm or an agency that sees to, apart from the human resource agencies within whatever entity, that would deal with those mental, because at the end of the day, these circumstances are related to, it is some disconnect, it's some relationship discord, some form of perceived control or manipulation or abuse that happens. And there is an absence of the agency that deals with that.
No, I don't think, I think you're getting it too broadly. What is happening, Senator Longmore, is the idea, it came up about who do you disclose to?
Right.
And the question is, why couldn't you disclose to a trade union as a GP?
Right.
And that should be protected. In other words, at the moment, you don't know what the confidant that you're disclosing to. If that confidant go and tell a newspaper or go and tell somebody else, whether they wouldn't reveal that it is this person who has said so. So you want it, that's still to be confidential.
Exactly.
So to the extent that the person has the courage or intend to go to the IC or to the Commissioner of Police or to the DPP, they know that they're when they reveal to these persons, at least until a matter comes up for trial and they get the consent, their identity won't be disclosed. But there are lots of them who doubt the process and don't have the confidence that if they go to one of these bodies, and some of them don't even know the bodies in the first schedule, but they would feel confident to disclose to a minister of religion or the trade unionist or the Jamaica Civil associations, so on. So what we want to be able to do, there's so much wrongdoing and misconduct at the workplace that we want an employee to be able to take it to someone they trust. And that someone they trust can say, all right, I will take it to the relevant body and protect your identity.
That's why I questioned whether or not the human resource unit within such agency does not play that role.
Well, you know,
because that is kind of within the agency and point of contact.
I must tell you, Senator Longmore, my little experience in government.
We'll take it outside.
My little experience in government is that most of the employees don't trust the human resource department. So that's the very last section.
Wow.
You'd be asking them to go to. So, you know, many employees, I must tell you, my experience in government is that they will tell an outsider before they tell someone in the department. And that outsider is the one who comes to the permanent secretary or the minister to say, do you know that that person has been abused or has grievance, but for that person to take it to the somebody within the department and expect redress, it's the last thing you're going to have happen.
It's an unfortunate reality.
I hope you understand. Senator Guy, one second. Senator Guy, then. Senator Guy.
Oh, thank you very much, Chair, but I'm still MP. All right. The positions, the various positions of the committee has been expressed, and we're going to ask CPC to draft something for us to look at it in that respect. But the other question I want to ask, Lance, why the Minister of Constitutional Affairs, why have you included that as another entity?
That's in Section 3. So I was going to say that Section 3 flows naturally from the discussion happening right now. So I'll be very brief on. I'll answer your question. I'll be very brief on 3. So at the time, the Ministry of Legal and Constitutional Affairs was newly formed at the time of us writing the submission. And there was an impression that this would be a particular ministry alongside, say, the Ministry of Justice that would be concerned with the rights and protections of Jamaicans, Jamaican citizens, Jamaican residents, whoever in Jamaica.
To be fair, though, Mr. Smith, the public defender, who has now restated the position of the public defender, anytime there's constitutional or administrative breach, then the public defender should be consulted.
Right.
Which, unfortunately, it has not been as proactive as it should be, but that is what the public defender is all about.
That's what the public defender is for. We appreciate the inclusion of the public defender in the first schedule, and perhaps that the lack of confidence in the office contributed to that particular suggestion of the inclusion
of the
LCA.
No, but with due respect, I think all of our public defenders in the past have been, persons not only of integrity, but they have acted with great objectivity. I mean, I think the problem with the public defender is that the people do not know enough. They have not been proactive enough to explain what they're all about. And I've said that to the present public defender. Jamaicans, unfortunately, unless you spoon feed them with information, they just don't know.
Mr. Smith, before you answer,
yes, exactly.
This submission is 3 years old. Yes. Are you still of the view that the Minister of Legal and Constitutional Affairs need to be included? Because as you said initially, the ministry was just formed then and you had high hopes for what came out of it. Are you still of the view that in terms of this list that they should be included there?
I can't comment on the position. I can't comment on the exact position of Lands on the inclusion of MLCA now. There hasn't been in our internal discussions since the submission. We haven't looked back at.
Could I therefore then ask, as the chairman did, in going back to your group?
We will definitely meet further.
And also justification for it.
Yes, we'll also meet further. I believe there was the pending issue of the support.
The obvious group way beyond the Ministry of Constitutional and Legal Affairs that should be receiving information of wrongdoings. And in fact, I believe, are actually now receiving such information is the parliamentarians.
No, but...
No, let me finish now.
Yeah.
Let me finish now. I have long heard opposition spokespersons and finance declare all type of top secrets. Not you yet, Jules, but I've heard that. So, civil servants and non-civil servants sometimes pass information to parliamentarians. I learned, for example, about a drill that was purchased for 27 million.
A what?
A drill, a neurosurgery drill, for which there's a meeting being held this morning, one for which I'm excluded. But the point I'm making, I learned this as a parliamentarian. And the point I'm making is that people do select and trust parliamentarians and provide information to you. You yourself, Minister, have said, bring it to me, I will be the informer. So I'm saying you probably want to consider lands, whether or not in that state actors, parliamentarians.
No, well, there's there's no doubt that the CPC is going to have the task of putting in place examples like, be it Minister of Religion, trade unionists, Justice of the Peace, custodians, and such other category as they feel confident can take their complaints to the relevant authority. So it could well be a parliamentarian, it could well be someone who is in the organization, but someone they trust that can take it. But they, if I might say so, colleagues, it is because of my understanding when I go into the community, people don't want to take matters, say, to the police. They will tell me, or they will tell a JP or a Minister of Religion, who can take the information to the JP. You take, for instance, a person knows that A has a gun in their house. They're not going to let it be known that they are the ones who reveal that A has a gun. But if they tell someone they can trust, let us say the MP, and the MP can get the police to go and find a gun, the person is not known. And that is the feeling, I believe, why a lot of wrongdoing and misconduct is not really exposed. And so, you see, CPC, so we want that formulation to take it involved. So we want to thank Lands, and we want to wrap up because we have the OUR. We want to wrap up now because we have the OUR to start immediately. So some final comments or questions. We start with you, Senator. No, one second. Shireen.
Mr. Chairman, and this is, well, I hope I don't invite anymore, but I just wanted to bring us back to, because I find us going a little wide, the objects of this act at Section 3. To facilitate and encourage the making in a responsible manner of disclosures of improper conduct in the public interest. To regulate the receiving, investigating, or otherwise dealing with disclosures of improper conduct, and to protect employees who make specified disclosures from being subjected to occupational detriment. I find it necessary to read that, Chair, because we are speaking about the addition, we're talking about two different things. There is first already existing in the Act a scheme of reporting of protected disclosures to prescribed persons and prescribed bodies. And those bodies have a duty to investigate the circumstances related to the disclosure. There is also, under the Act, disclosure to the employer in an internal situation in that company, that workplace. And that employer has a duty to investigate, and there is a process that that employer is required to follow, developed internally, but consistent with the Act, in how they receive the disclosures and how they engage the investigation. What I think we have been discussing this morning is an additional scheme, which is to permit a person to report to someone who will then take that disclosure, or rather to disclose to someone who will then take that disclosure and report it to one of the prescribed bodies. The disclosure will then be protected I want us to kind of think about that a little bit, because if you are saying that someone can report to that person, this intermediary, what is the duty of the intermediary under law that we are prescribing? Because for every duty, the failure to carry out a duty must have some penalty. Or are we saying, are we offering this simply as an option? And if we're offering it as an option to persons to make a disclosure, say to a minister of religion or whatever, whoever that is, what happens to that person where the intermediary fails to do anything further? I just want us to think about that. I'm not pronouncing on it. It arose out of the discussion, and I'm just offering that to the committee for consideration.
No, it's a point we need to just tie up in a short while. Yes,
yes, Chair, thank you. And I just want to, having absorbed it a little bit more, I cannot help but recognize the likening to any other case of abuse. We have a system where persons who are recognized as being abused in more heinous ways, so to speak, directly, physically, emotionally, sexually, etc., there's an avenue for reporting such that is protected. And the persons who receive that information are obligated to act. Now, what we are here discussing is basically corporate psychology or corporate psychiatry, because that victim is perceiving some form of victimization, which is abuse, so to speak. And so we don't necessarily need to reinvent the wheel, but what I'm definitely suggesting is this first schedule be expanded to include healthcare workers or doctors or mental health workers who would be, as in any other case of abuse, be obligated to act and could then be guided to act accordingly to the other agencies listed.
Well, we have to be careful, as they say, Senator Longbourn, that CPC is pointing out that the first schedule, the list there, constitute a body. Once a report is made to any of those members in the first schedule, they can act. Now, the names that we have been tossing around, doctor, minister, trade union, we see as intermediaries who would take it to the relevant person in the first schedule. In other words, a doctor, for instance, who has seen evidence of abuse has a duty to report it to the police or the relevant authority. But the doctor, him or herself, can't really do anything apart from treating the patient. But in those instances of abuse or misconduct, we expect that when it is reported to the IC or the public defender or the DPP, that they will take action not only to resolve the matter, but if necessary to punish the offender or to take action against the offender. Now, the question that Senator Golden pointed out, I don't think we can put a burden on that intermediary, to report, because that intermediary, when someone comes to that intermediary and say, this is happening in this company, they don't know, they can't, and it might, a person might be mischievous. So what would be necessary if the intermediary feels that there is some merit in the allegation and they take it to the DPP or the Commissioner of Police or the Public Defender, what one would hope is that that first scheduled person would do their investigation to see if there's merit in the allegation. But to put the burden on the intermediary that, because I told you, Mr. Trade Unionist, you represent the union, and you have done nothing about it, and therefore I'm going to report you. And then, the trade union is, it wouldn't be right. No, but what we are really saying is, what we have been discussing, and I hope we are agreed, that there needs to be an intermediary that persons have trust and confidence who they feel and believe they have a meritorious complaint. They don't want to go to the first scheduled person, but they feel that this person, the intermediary they're reporting, will take it to the relevant first scheduled person. And that is where we're asking CPC, if we're agreed to, yes, but CPC, if we are agreed that CPC can give us a formula that we to expand, you know, in our report, that we have agreed that there could be an intermediary who will be relied on to take the matter to. But I would not want to put any burden or any, you know, penalty on that intermediary if they fail to report. Sorry, no, one second. Yes, yes. Okay, go ahead.
No, I wasn't. I want to say that I just wanted to remind us of our initial discussions on this matter, which took place some long time ago. But the fact of the matter is that I think there was general agreement that what we call the Whistleblowers Act, whistleblowers legislation, was not working, that we had actually not had any reporting under the legislation. And so part of what we were looking at is how we could fix that. And so I think the recommendation for the intermediary is highly appropriate and would address some of the concerns which were raised initially. I support you, Minister, Chairman, that we wouldn't want to impose penalties would be to restrict the willingness of an intermediary. And I think it should be quite the opposite. I think we should encourage an intermediary to report to these prescribed persons who can then follow the rules and the processes which have been laid out in, I think, 18 or 19.
Quite. Thank you, Senator. Sure. Yes.
Following on what the member just said, we also, in light of that, need to take into consideration Section 24, which is any person who contravenes or reveals, and there's a penalty that is attached to that. Yes. You know, we can be guided by what CPC presents to us in terms of that.
No, and in fact, it's consistent with the speaking to an intermediary would be like the lawyer-client relationship. So the intermediary should not should take the information as confidential as they take it to the first scheduled person. Okay? Sorry.
Belabor this. But so in that case, if that is a scheme that we are looking to put into
expand the process.
To expand the process, then why are we prescribing who the intermediary is? Why are we prescribing for any citizen who has knowledge of improper conduct and wishes to disclose that in the public interest, any restrictions on the person of... Hold on, let me finish. The person with whom they, the person that they trust, the person that they have confidence in. If the intermediary is simply that person who takes the information given to them, reports it to the prescribed body, who then has the duty to investigate, and that investigation necessarily requires them to interact with the person who has complained. So if that person is even fearful to go directly, at some point they are going to become a part of the process, because there's going to be a need to understand the complaint that they're making, and a process that requires them to review, to go back to the employer to see what is going on.
No, with due respect, Senator Golin, not necessarily. That intermediary, if they have a good brief, and no doubt that intermediary, be it a trade unionist or...
No, Minister, you're not here. No, let me finish. I want to express my thought. I don't want it to be summarized. The point I am making is the intermediary you're talking about is somebody that makes it easier for the citizen. It is not taking into consideration the intermediary having any other function other than to give the disclosure to somebody else. So I don't know what brief an intermediary would be getting and what capacity any intermediary would have to receive a brief. if it is about the trust and confidence that the reporting person, the whistleblower, is to have, they have to pick that person, that it's a personal choice for them. So we can't prescribe the person with whom they're going to have trust and confidence in if what we're trying to do is put in place a scheme for an intermediary, somebody they trust to take the complaint. Now, if you're talking about something else, if you're talking about setting up some other prescription, that's a different matter, and I need the committee to understand the distinction between the two. Because if you're going to prescribe something, then you're talking about a whole nother scheme of prescribing people that we think the citizen is going to have trust and confidence in, not the actual person that an individual chooses to disclose it to.
You will recall I said, and such other persons in whom they have trust and confidence. So it may well be, you could say to an employee or to anyone who has knowledge, good information, they can go, maybe an employee, to the trade unionist, they can go to the minister of religion, who they go see at church, hopefully regularly.
But if you're going to put that in, Minister, what are you prescribing?
No. All I'm really saying, and such other persons that they have trust and confidence to
the
report it to someone in the first schedule.
The minute you include that, there is no need for the provision. If you are making it as broad as such other person that they have trust and confidence in, then tell Jamaican people, anybody you have trust and confidence in, you can disclose this to. It will be protected.
No, one second.
Goes to a prescribed body.
Yeah, yes, go ahead.
Chairman, may I? Chairman?
I raise
go ahead.
Point of order.
Chairman?
This.
One second.
We have guests here.
Yeah, go ahead.
And guests are making their submissions to us.
Yes.
There's going to be ample time for the committee to have these internal discussions. And I propose that we give the time to the guests to complete their proposal. And we will come back because the decision is ours to make.
All right.
That's my point of order.
All right, good point. I think Minister Fort, you wanted to come on?
Yes, Chairman.
Yes, go ahead.
I've been listening for a while on the exchange. My understanding is that Lands is saying that there is a gap in the law. There are informants who may not feel comfortably in passing on information, and the law should make provision for them to disclose to some other person, and that other than an attorney at law, and for that other person to then become the informant. Is that a proper understanding of what is being requested?
The conveyor of the informants, a filter for the informant. Go ahead, Minister Ford.
Oh. I'm sorry. I'm getting an unstable internet. Right. And your proposal is what? So my understanding of the request is a correct understanding that they see a gap in the law now, which requires provision to be made for some other person to be the third-hand informant?
No, all right. Minister Ford, you can put on your camera if it's possible. But I think the point is that the feeling, and this is where the committee, needs to crystallize it better, not necessarily now, but that there are many informants who don't have the trust and confidence or knowledge to go to one of the persons in the first schedule, be it the DPP, Public Defender, Commissioner of Police, as the case may be. And what is being suggested is that if the law provides for them to tell it to an attorney at law, trade unionist, or someone they trust who they know will take it to the relevant first scheduled person to act on. I think that is what we're looking at.
We have to be careful that we're solving the right problem. And I think you are correct to say that there are many Jamaicans who are distrustful. But at the end of the day, the purpose of the disclosure is to ensure that action can be taken where there is reason to believe that there is misconduct taking place. So the information cannot be disclosed to any and everyone.
That is correct, yes.
So we would have to ensure that we're solving the right problem of helping to build confidence where it is required so that at the end of the day, the appropriate action can be taken. Senator Golden Campbell has been reminding the committee of the purpose of the legislation. And I think I just want to join her in commending a reminder of what it is that the law is seeking to do. Protecting disclosure in certain circumstances. And so not every request can be accommodated within the ambit of the legislation, even while we acknowledge that the problem identified is a real one. So we have to take care to ensure that we're solving the right problem with this legislative tool.
I think it's fair to say, Senator Golden Campbell and Minister Fort, we're struggling to find out how can we make this Protective Disclosure Act more effective. In other words, informants, persons who know of wrongdoing, misconduct, problems at the workplace, they're not necessarily disclosing it because they don't feel confident to go straight to a first schedule person. So we're looking for the intermediary who we feel they have trust and confidence who can take it to a first schedule authority.
May I suggest that in the interest of time that the request be noted and we move on to other provisions. Because the deliberation may require further consideration, and there are other matters to be heard in
So
today's
we're going to, consistent with what you said and the point of order of Senator Brown, we're going to cut it now, and I think the CPC have a good idea. She might be able to help us when we come to the discussion, further discussion. Yes.
I just wanted to seek some clarity under your employee protection, specifically 2.4. That speaks to section 17, where you wanted a mandate that the proof of the employer shows evidence. And I suspect that you're speaking to that last part of the clause that speaks to unless the employer shows that the act constitutes the occupational detriment is otherwise justified.
Yes.
Isn't that sufficient enough for evidence in terms of its coverage? And I'm seeking clarity on where you are suggesting and applied evenly among all employees. I'm not quite understanding that aspect of it.
Okay, so consider the situation where it's common for employees to inadvertently or for whatever reason commit minor infractions. And at the time of these infractions being committed, they're not sanctioned, but they are noted. These are possible back pocket reasons to punish or terminate employees later on. If an employer has that reason and they have the evidence that a particular infraction was done, that is in fact a justification per section 17. However, if time passes, if like a long time passes, and it's not common to sanction employees evenly, fairly, and timely, and when it comes time to disclose, an employee faces sanction for what they did long ago, you could say that while there is a justified sanction, it's being used to quash a disclosure, which goes against the spirit of the act.
As one who have been in around the corridors and through the doors of the IDT over the last 50 years, the burden of proof our dismissal being justified rests with the employer. So that covers what you're asking for. They have to prove that their action in whatever the detriment was justified. So
okay.
The law covers what you're asking.
The Protected Disclosures Act or other legislation in combination?
The procedures, the Labor Relations Industrial Dispute Act.
Okay.
Okay. Well, Mr. Smith and your colleague, we want to thank you for coming in.
May I do like a 2-minute lightning round
sure.
for the rest, because there were items. I will be very quick, I promise. 2 minutes.
Quickly,
okay.
Go ahead.
Yes. So I thank Senator Gale for making mention of Section 2 of Suggestion 2.4. That was a very important one to us. As to the question of what the responsibility of additional persons of the intermediaries, we did consider things similar to that. We found Section 6.2 requiring 24 hours to write a disclosure that's heard orally to be a bit too rigid. We suggested 2 or 3 days to note and to write and document oral disclosures, but perhaps that could be longer. That's compatible with those comments from the committee due to the spirit of making it easy to facilitate disclosure, as well as to facilitate disclosure in the first place. The groups who met also found concerns with the language in Section 5 on good faith and public interest, specifically who determines what counts as a good faith disclosure in the public interest. Some persons in Lands suggested the phrase good faith be removed. And then the last bit, I believe Section 24 was mentioned by the committee. There's a penalty penalty of $2 million and 2 years or 2 years imprisonment in Section 24. In Section 23, in Section 23.2, there is a penalty for 250,000 Jamaican dollars or imprisonment no longer than 3 months. There was a group that suggested the fine be raised to 2.5 million Jamaican dollars or imprisonment up to 3 years. So that, in brief, covers the rest of our submission.
Well, certainly we take some of these into consideration when we have our deliberation, Mr. Smith and Jamaica Lands. Certainly the penalties we will look at, whether we go as high as you have suggested is for the committee, but where it is now, it is low. So the likelihood is that it will be adjusted. Mm-hmm. But we want to thank you for your deliberations and for your input.
Thank you very much.
If you have any other suggestion, you can always send it to the secretary. Okay, thanks again.
I'd like to say it's been very heartening, the level of discourse from the committee.
Sure.
Yes, thank you.
Thanks again. And I want to welcome the OUR, represented by Mrs. Lorraine Patterson-Walters and Ms. Cheryl Lewis, and we can let you begin right away.
Good morning, members of the committee. Thanks for facilitating us in our presentation to you. I would presume you have our documents, and I will just try and go through very quickly. Yes, the PowerPoint presentation.
They did present a document. Right?
Yes. So, by way of background, just to note from the legislation that the OUR operates in 2 capacities, one as an employer and the other as a prescribed person under the first schedule, which you have been discussing. As an employer, the OUR is required to facilitate internal disclosures by employees, and as a prescribed person, under Section 9, fixes the OUR with the responsibility to receive, treat with disclosures by persons employed to other organizations where those employees reasonably believe that the conduct disclosed fails within the areas of responsibility of the OUR. I hear from the committee on my entrance whether you wanted to know whether any disclosures have been made to us. There has been no disclosure to us. Our internal procedures are complete in place and in terms of the policy and procedure. With regard to the external process, which is the prescribed, we sent our document to the Integrity Commission. The Integrity Commission have made some comments on them, and that document is being reviewed to comply with the comments of the Integrity Commission. So that's where we are at on that.
You said that there are no disclosures internally.
No, we have not.
Right. Secondly, that as a designated authority, you
as
have
a prescribed authority.
Prescribed, you have not received any either.
No, we have not.
Okay.
In the almost 14 years since this act,
what we send to the Integrity Commissions, we are required to develop procedures to guide how a person should come to us when, how, and both internally and externally. So what I'm saying that our internal procedures have been completed, but our external procedures are we drafted a document and we sent it to the Integrity Commission for them to sign off for their approval, and they have returned their comments to us for some changes to be made. So.
I just need to ask, so clarify for me the requirements for an external procedure. Who would this external procedure be directed to?
Under the Act as indicated, we are a prescribed person.
Yes.
On the first schedule.
Yes.
That persons can come to us and to make reports.
Right.
So that is a procedure which we are intimating to the public to be published on our website as to how they are to conduct themselves when coming to us.
Which may invariably assist the process.
Yes.
Because maybe the people don't know the process now.
They don't know the process.
Okay.
So in relation to the substantive act itself, in the first comment which we have of employee, and the concern there was related.
From 2022, you know?
Yes, or before that, because I think it was just before COVID. And it went through several drafts because our processes in the OUR is that it is drafted, it has to go to our technical committee, then it goes to our board, and then it goes to... Back to the more substantive matter. The employee, the definition of employee. Our concern there was with board members. When we looked at the provision, it can be implied, in particular at paragraph A, that a board member may be included. But in our research, we found that in several jurisdictions, because of what has happened within the wider context of the society and in companies and the various scandals which occurred, those jurisdictions felt it potent and effective to break out simply just to say employee, to specifically include a board member. To intimate that a board member falls within the strictures of the Act. And so that is our recommendation, that in the interest of good corporate governance and the public interest, the protection should be explicitly stated that it includes board members. So that is our first comment. Our second comment relates to Section 2, again, of the definition section, and that is improper conduct. We also noted that interpersonal grievances should be specifically excluded and that these should take the route in dealing with them under the regular HR and normal internal procedures. And why we said that is that although we recognize that sometimes personal grievances may be intertwined with a protected disclosure, we thought that it would be best if we could unhinge them, disconnect them in some instances, to say that personal grievances in and of itself ought to be taken by route of an internal control procedures, and protected disclosure, if it even involved personal grievances, would be borne out and be dealt with according to the Protected Disclosure Act.
Mm-hmm. I think it depends on the nature of the interpersonal grievance, and in our workplace, the lines are blurred between personal and what is professional. And so I wouldn't want to exclude that totally. I think it should remain, and depending on what arises from the complaint, you make a determination about how to deal with it. But I wouldn't support a blanket removal of it.
And I may add that personal grievance might be relevant to the employment. You know, the personal grievance might well be against someone over whom authority is being exercised. So you see, you can't really exclude the personal grievance per se. It depends on the nature of it. I mean, if it's something between two employees at the same level, but sometimes it is, you know, at a higher level and a low level. Yes, Senator.
Chairman, I am not so clear on where in the definition of improper conduct personal grievance would arise if it didn't fall under any of the 9 listed conditions. Personal grievance alone would not rise to the level of something, a disclosure that would be protected, because it wouldn't be considered improper conduct in the context of this act. So my question is, have you seen scenarios arise that give you that concern? Because I don't think we have that problem in terms of how the act is structured.
From our perspective, when we looked at it, although it is not explicitly stated, we were more thinking of the Jamaican context, where...
Give me an example. Like, what do you mean by, yeah.
So in terms of if somebody has a personal grievance against somebody else, and they think that they ought to be protected if they reveal that personal grievance, whether or not they should be brought under the umbrella of the protective disclosure. So it was more like for clarity.
Yeah, but I think it is clear that that would not fall under this act, because there's nowhere, unless they are saying it's a criminal offense, the personal grievance involves a criminal offense, because it could. You could have a personal grievance in relation to some sort of improper conduct of a sexual nature, of a harassing nature, and in that case you'd have the Sexual Harassment Act, and this act that would come into play. But personal grievance simpliciter without anything more, I don't see any
it's not included.
Lack of clarity. Yes.
Okay, if I should move on then to occupational detriment. The Part G of that, if we go to the definition of occupational detriment, Part G only speaks to the provision of an adverse reference. And we found that In many instances, an individual's ability to obtain new employment is in part dependent on a reference, whether in terms of internal promotion or external promotion. As such, employees should not be allowed to refuse an employer reference or provide the employee an adverse reference on the basis that the employee made a protective disclosure. And this, when we looked at other jurisdictions, for example, I think it was South Africa. South Africa made the provision that you should not refuse a reference as well as provide an adverse a reference in relation to a protected disclosure being made.
But here again, you know, it's going to be very difficult to force an employer to give a reference that is suitable. You know, in other words, my view is that an employee who needs a reference to get new employment is expecting a glowing recommendation. If you say that I should force an employer to give a reference, that employer may well give a reference which is not only ambiguous, but might be unuseful.
Minister Chalk,
yes.
Chairman, I believe that the issue of reference is a matter that needs to be addressed. And it should not be looked at entirely from giving a glowing reference. But I do believe that it is helpful to employer and employee and the public interest that references be provided as people move from one employment to the next. You know, I think we have been looking on this issue in an unhelpful frame. But the bigger point is a recognition that references are usually required and requested, and whether in a case where a disclosure has been made, the reference should be denied.
Mr. Chairman.
Yes, Senator Golden, then.
There is no
Robbins.
requirement in law for me to give any employee any reference to go anywhere. So
that is acknowledged through you, Chair Senator Golding. That's not the point. I was not saying that there is no such a requirement. I'm merely saying that this is an issue that has been raised repeatedly and would need to be considered generally in the employment law sphere.
And I am disagreeing with you, Minister Malahoo.
I am not answering the question to say that an answer should be provided. I'm not making a suggestion at this time. I'm merely pointing out that this is an issue that has been raised. Once it is considered, a decision can be that legislating is not a way to address the problem at all. And maybe that would be the better view, but I am not at this point concluding on the matter. I'm merely raising it in the context of what Ms. Lewis is saying.
All right,
and I share your perspective, Senator Golding, through you, Chair, that it is important at all times for us to bear in mind what this law is seeking to do, and to ensure that while genuine issues are raised, we consider whether the legislation is the appropriate place to respond to those issues.
All right, Member Gill, then.
So I'm not carrying any brief.
Chairman, with respect, can I make my point, because I haven't asked the question that I wanted to ask. Sure. I'm trying to understand from the OUR. If there is no requirement for me to give a reference in law, right? What are you hoping to protect? Because in practice, when an employee thinks that they're not going to get a positive reference from a particular employer, they don't ask for one. They move on, they make their case in another place, and they do, you know, they move on to something else. So what is the gravamen of the protection that you're asking for?
Okay, so if we look at it from the context of the central government, where a person sometimes would move from one entity to another and would require their substantive position employer to make a reference for them to move to another entity, whether on secondment or whether a promotion, then if there has been a protected disclosure in some way, a refusal may be a form of victimization on that employee to give them that reference so that they can move along because of what they have reported.
So don't you think that that would fall under improper conduct as it is defined here? Wouldn't that be conduct that is gross mismanagement, impropriety? No, sorry.
No, I think we're looking at occupational detriment.
So, right. But I'm saying if someone were to do that, refuse a reference for a protected disclosure, wouldn't that refusal, if it is not consistent with the person's performance, and you're talking about the public sector context in which performance appraisals are regularly done or are supposed to be regularly done. So if you get a reference that's not consistent with that, or a refusal for a reference which is not consistent with the person's performance over time, wouldn't that then fall under some sort of improper conduct on behalf of that employer in relation to that past protected disclosure?
A refusal of reference means that the other person don't know or can't judge based on the person's appraisal, which would have been given if using that example. So a refusal of a reference, meaning that I would wish to move, but I need a reference from my current employer to go to the next employer. And within the civil service, as the example I have used, that is an occupational detriment. In a similar way, a refusal, an adverse reference because of the protected disclosure which would have been given would operate. So one is an omission to do something, one you commit to doing it, but doing it in an improper manner.
Right, but so what I'm saying is
the distinction which we're trying to make.
Right, but if the fact of a reference is at the discretion of the employer, and the employer can exercise whether or not he or she wishes to give a reference, how would you define that as occupational detriment if they refuse? Because they can, without the protected disclosure, they could refuse to give you a reference. So, in other words,
certain instances in the civil service, based on my experience over the years in the public service,
there's a duty to give a reference.
Yes, in some instances.
Senator Brown might be able to explain.
So here is.
One second. Could I just, CPC want to just intervene here? Just 1 second. CPC?
Yeah. Well, yes, because I was considering, in light of paragraph G of the definition of occupational detriment, which makes providing an adverse reference an instance that might be occupational detriment. But then if we were also to include the refusal to provide a reference, then that seems to put the employer in a position where, in order to avoid this allegation of occupational detriment, the employer would have no choice but to provide a positive reference. That would be the result of providing additional.
So 1 second. So that is the very point that Member Robbins brought up. What do you expect in this reference? One second. Go ahead.
So here is the situation. We don't yet have an employment law that would make provisions that mandates an employer to make a reference. Some employers does this based on their own policy. Now I'm understanding that the extension of the provision of adverse reference was seen in this context as a consequential impact of occupational detriment. So to protect the employee if they were to have raised an issue against this consequence. And I think we may need to consider in an additional consequence now about providing a reference, but that is only stipulated where an employer in their own policy provides reference, because some doesn't, you know, and they won't. I know of some employers who say, John Brown worked here from 1999 to something, and they were employed as. That's all. But not this glowing, golden type reference.
That the employee wants.
That the employee would want.
Member Robinson, yes.
So I was going to say what Member Gill said. Which one is worse? If you are a prospective employer and you say a reference, say, John Brown worked for 9 years, full stop, that's not the biggest red flag you're going to have. It's better you never get a reference. So I'm just saying you have to be careful about trying to legislate something like this. The reality, I understand that there's the potential for victimization, but insisting that an employer must write a reference is not a good thing, and I don't think it should be legislated.
Chairman, I don't think we have to follow other jurisdictions, but usually it's a good guide. South Africa has been mentioned, and we could examine whether or not there are other jurisdictions that have such things.
Okay.
And I also want to suggest that we ask our technical people to look at whether or not there's a ILO recommendation or convention that addresses this. Address the issue of reference and giving of reference and moving on from one employer to the next. So before we conclude, and we're not intending to conclude that today, I'd ask for that research on the international organization.
What has been suggested,
which is best practice.
Right, Ms. Lewis, is that if you could assist us, but we will also check and see which other jurisdiction mandates, you know, employers. I can't see how. I must admit, I couldn't support that you mandate an employer, because you're going to get a reference which is tantamount to an adverse reference.
And if that comes and it's not truthful, the person who made that protective disclosure needs to be protected. And that's what I'm saying. Let's do a little research.
No, not a problem. Yeah. We will, Mr. Nash, just if we have any additional information on it, maybe that particular legislation you mentioned from South Africa, and how it has.
Chairman.
No, 1 second, Minister Ford. How it has, if it has ever been utilized in any way. Yes, Minister Ford.
Just seeking clarity again from Ms. Lewis. What is the proposal that Ms. Lewis has made in respect of the recommendation? I just wish to be reminded. I'm now uncertain.
Well, what is in the body of her material is that it would be occupational detriment where an employer refused to provide a reference for the employee. So what the converse is that the employee should get a reference when they're moving on. Is that so? And we're saying we don't think mandating it. I think
so the issue is being discussed in the context where there is no mandatory requirement for a reference to be provided. Right, but where one is being where it is either the policy or practice within an organization for references to be provided, it would become it could be viewed as an occupational detriment if there is refusal where the employee had which is protected.
You broke up a bit there, Minister Ford, but let's say...
Yes, I'm saying that in a context where there is no mandatory requirement for recommendations to be provided, but recognizing that there is a practice and policy in some places where references are provided, my understanding is that she's saying in such a context where either by practice or policy it is normally done, if there is a refusal for an employee who has made a protective disclosure, then it ought to be viewed as an occupational detriment. Am I getting it through you to Ms. Lewis?
Ms. Lewis is bowing her head. She said,
yes,
you're correct.
That is our interpretation, yes.
But we will research it some more.
Yes.
Right, so I don't think it is helpful to then consider the issue as to whether
No, you're breaking up Minister Ford, so we haven't heard a thing for the past 15 seconds. She's on the road, clearly.
Because it is not in the wider sense.
No, Minister Ford, you're breaking up regularly, so we're not hearing you. So we're going to conclude this particular section to say we will get better particulars, okay?
Yes, we have noted the concerns, and we will
ask for
make
better
our
particulars.
research. And
wonderful. So move to the next, please. Yeah.
AG are one of those government legal departments. Could just check if the staff order, since this will apply to a large extent to government employees, if the staff order has any requirement for reference for people leaving the job.
If a person is moving...
Because we don't need to exit interview and all
right.
those things.
If a person is moving from one department of government to the next, whether staff orders require a reference from the previous department, I don't know. We could check on that.
Just to say, Chairman, that I am of the view that where an employee is moving from one place in government to another place, reference is to be provided, because we certainly, the public interest is not assisted by moving a problem from one place to the next in government. But this is not for a determination in this context.
All right, but it's to be considered further. All right, yes. No, Lands, they know, you can leave when, or if you're happy staying here, that's fine, but I mean, you can leave whenever you want. Very good, so we don't have a problem with you remaining, okay. No problem. All right, could you continue, Ms. Lewis?
Yes, if we should move to section 13, and this is a drafting. The marginal note speaks to procedures for making disclosures internally, but the section, actually, section 13.1, contains a requirement for employers and prescribed persons to establish and operate procedures for receiving, investigating, or otherwise dealing with disclosures. And it is our understanding that disclosures made to prescribed persons are not considered internal disclosures as such.
Well, let's ask CPC, is that...
The marginal note should include
is that of any significance?
That we could delete the word internally from the marginal note.
Okay, very well. We can move on.
Section 13.5 places a duty on designated officers to keep employees who make protected disclosures updated on the status of investigations of the said disclosures. However, there may be instances when withholding of updates may be necessary to avoid prejudice to the investigation of either criminal, civil, disciplinary, or any other regulatory action. And it may therefore be prudent for the provision to indicate that updates can be limited or withheld in those circumstances. So it's to accommodate the practical working out of an investigation. So it's suggested that the provision be amended to require that updates be given to employees only to the extent that it will not prejudice an investigation.
The only problem I have there, Ms. Lewis, it then becomes very subjective. To put it that way, I would say that if you make it broad, update on the status, they should be updated.
Yes.
Right?
We agree.
Now, as far as I'm concerned, I have no doubt that they're updated regularly, but to say restrict it, because a subjective decision is made that to update you might prejudice the disclosure. I'm not too sure how that is correct.
The challenge I would have is that you would have to be saying something to that employee if it gets to the level of a restriction, because they go and ask questions. So what is happening? And that on its own may prejudice an internal investigation or external investigation that is taking place. There is no limitation as to when you provide an update. It never quantify if it's quarterly or monthly or whatever. You're just providing update. If there's no update to be provided, there's none.
And I suspect the update may well be the matter is still under investigation.
Right.
There may very well be an update, but the nature of that update you can't disclose at that point in time.
So don't say nothing.
You see, I'm not too sure how you would deal with it.
You really don't want to prejudice it. Or you don't want to amplify to the individual to create a kind of expectation. Yeah?
Okay.
So sometimes the best update is no update.
No. Can you imagine you say, I can't tell you anything because the matter is at a sensitive stage? It would be, it would reveal it too much. Yes.
Can you tell me where the legislation speaks to a outlier in terms of time? It doesn't, so I think I'm not necessarily agreeing with the Ms. Lewis here, but the truth is that what is to prevent the officer from basically not doing anything over a period of time and there's no update to be given? I know there are some sanctions there, but I mean, the truth is that where an employee makes a disclosure under this section, every designated officer shall give the employee updated on the status of the investigation of the disclosure. Now, is there a outer limit?
Because you don't have to inform, But in fact, to inform might be prejudicial.
Exactly.
It may well be so. Yes.
A guide for us in terms of setting time frame and so forth. Sorry?
You see, I'm not too sure. Our colleagues, are you thinking there should be any change to this? I'm not too sure. Okay, we'll leave it as it is. Okay, Ms. Lewis?
Okay.
Next one.
Okay, section 13(1) places a duty on employers and prescribe persons to establish and operate procedures for receiving, investigating, and otherwise dealing with disclosures. And section 13(6) places a duty on employers to ensure that information concerning procedures for making disclosure is circulated regularly among employees so that they are made aware of the procedures. However, there's no similar duty placed on prescribed persons to ensure that those who may disclose to them are aware of the procedures for doing so and that this should be addressed. And our recommendation there is that a provision be included to impose an obligation on prescribed persons to circulate information to the public concerning the procedures for making disclosure.
And this is where you come in. Have you done it?
This is where we come in by developing our procedures, submitting it to the Integrity Commission, and is incorporating it.
No, because to the best of my knowledge, it is only the Integrity Commission who has actively been advertising and indicating to persons that they can so inform the Integrity Commission.
Yes, they have.
Now, I would hope, you see, that, in fact, having had discussion with the public defender, she now must really promote her office to say that if there are administrative and constitutional breaches, we are open and available. And I suspect the same with you two at the OUR. You too should be, in other words, the 18 or 19, 18 persons, authorities, prescribed persons, 19 with the IC. Well, the Contractor General is out, subsumed under the IC. The point about it is that all of these institutions, certainly the Auditor General tells all the departments, so we know that. The Auditor General is always in various departments. Bank of Jamaica is advertising, but I'm not too sure that they talk about wrongdoing anywhere. But the children's advocate is very, very proactive. The Commissioner of Police, obviously, that is, anybody can report. But I would agree with you that, you know, this body, we should be encouraging, and maybe ask the IC to indicate, just as they've done with you, OUR, that the other areas, how they could, in fact, assist the other prescribed authorities to publicize a process. You remember you were here when we were having this discussion. How do people get to these prescribed bodies? And that is something we will be discussing later.
Because they are suggesting the imposition of an obligation. And when you impose that obligation, it requires a certain type of response and consequence.
And penalties.
And penalties. So I would suggest that it's more an encouragement in nature.
It's a guidance.
A guide
yes.
in nature rather than an imposition.
So I would hate to think that we prescribe that every year you should publicize 12 times and you only did it 10 times and we then charge you.
Chair, that is not our suggestion to prescribe timelines, but to impose an obligation, that they have an obligation
I don't think
to do so. And this is left up to them now to work out how it is done. I mean, for example, with the OUR, we intend to incorporate it in our public education, place it on our website, that sort of thing.
All right.
So it's not to prescribe a timeline to say you should do it 10 times a year, because resources, of course, would dictate otherwise or may dictate otherwise.
CPC would like to assist us here.
Yes, I think what is being suggested already falls within the oversight function exercised by the designated authority, the Integrity Commission, under Section 21. So if you look at 21.3 and specifically paragraph C to F, that is where the role of the Integrity Commission will come in to make recommendations about the procedures to be implemented by prescribed authorities, for example, to include implementing and monitoring public awareness programs aimed at informing and educating employees, and the general public in Jamaica about making, in a responsible manner, protected disclosures, and about the procedures for receiving and investigating such disclosures, and F, make recommendations to any person arising from any review under paragraph C or D. So it would be a matter for the Commission to interact with the various prescribed.
As it has been doing, I think.
Yes.
Mm-hmm. Speaking of mic there.
I'm saying, just for the record, I note that JIS yesterday was on Twitter advertising the Protective Disclosure Act, which was good, and I want to commend them for so doing.
No, and to be fair, I also see the IC advertising too. And I have no doubt the OUR, in due course, should also let it be known that, you know, disclosures can be made to you too. What I think is useful is I don't know how we could do it, but we should at least let it be known that there are about 15 or so bodies prescribed. Parliament, maybe the duty maybe in Parliament occasionally to publicize that, because it's a commission of Parliament. Okay? Okay, thanks. Go ahead. So we're at 15 now, section 15.
Yes. Section 15.2, we highlighted, provides for the exclusion of liability in relation to the making, receiving, investigating, or otherwise dealing with a disclosure. And this is clearly for us, out of an abundance of caution, it should be made explicitly clear that while persons will receive immunity in respect of the aforementioned, immunity will not apply to their involvement in the improper conduct that is the subject of the disclosure. And so it is suggested that a clause be included indicating that immunity does not extend to the participation in the disclosed impropriety. And that's just out of an abundance of caution. We felt that that point should be made.
CPC, is that really necessary? I mean, isn't it more or less implied? Let me hear from your CPC. All right. CPC will have a look at that and to see, and we'll come back to it. So would you like to go on to section 18?
Yes. Under section 18.3F, it places a duty on persons to whom a disclosure is made to ensure that the rights of the employee making the disclosure, any witness, and any person alleged to be at fault are protected. And we anticipate a challenge for designated officers of prescribed persons to be able to comply with these provisions, because they will likely have little or no authority to address the rights of the disclosing employee or mitigate occupational detriment of that employee. Similarly, these designated officers may have the power to protect the rights of witnesses in these matters. Protection of the rights for these individuals may have to be obtained through Ministry of Labor, IDT, court, or some other process. As such, designated officers of prescribed persons should perhaps be exempted from this duty. And it is recommended that designated officers of prescribed persons be exempted from the duty set out under the relevant section.
Any comments from colleagues?
And this is solely in response to the designated officers, not the prescribed persons.
Thank you. All right, we need to, I'm not too sure we have a position. Yes.
Okay, if I should quickly move on to section 19.
Yes.
Section 19.3 imposes an obligation on employers to provide reasons to an employee within 15 days where the employee decides to refuse to carry out an investigation in relation to a disclosure. There is no similar provision, obligation placed on prescribed persons. So whilst internally they must provide reasons within 15 days, there's no obligation on a prescribed person under the first schedule. So it is suggested that an obligation be placed on the prescribed person to provide reason to an employee within a specified time where the prescribed person decides to refuse to carry out an investigation in relation to a disclosure to it.
Well, first of all, I mean, I think it would be a useful provision. At the moment, so very few, as you have found out, disclosures are made. Now, can you imagine an institution, let us say Bank of Jamaica, designate a person to carry out investigation when a disclosure is made, and that person never receive a disclosure? That person would be basically unemployed, but employed. Would be underutilized. Could be doing
other things. No, that's just one thing you add to them. The children advocate, for example, as trafficking added to it. So you could just add that to the substantive work, especially since it's likely to be so few.
So what would be, you would be proposing then, Senator Brown, is that all of these prescribed bodies that we have prescribed, they should designate someone to receive disclosures, which mean that they would.
It really doesn't mean that you're going to create one single solitary special defined role to do so.
Yes.
But that might be an added function to an already established role. What this is seeking to do is to somehow inject that action must take place within a specified time frame, which is important because on both sides, you know, things can language.
I think it's, if I might say so, colleague, it's something useful to put forward.
Yeah.
Where CPC, in the Act itself, the prescribed bodies, and certainly one or two of them should be removed, like the Contractor General, and just leave the Integrity Commission. The Integrity Commission, as it is now presently constituted. So we may have about 15 or 16 bodies that we would put in the legislation that they should identify an office or officer to whom the complaints will be addressed and who should carry out the investigation where necessary. Is that possible?
It out of the current provision that would govern it, which would be the same one we were discussing earlier about the prescribed persons establishing procedures for receiving complaints.
Because to be fair, CPC, for this act to really be functional, you need some processes, you know, you need some process that people can follow. Because at the moment, after 14 years or so, OURs indicating they have had no disclosure, and I suspect if you ask the other bodies, they may have very few, if any. So we need a process that encourages, you know, affected parties or people who know about wrongdoing and misconduct to be able to, you know, report them. So CPC, we need a little formula or something. Sir? Yes. Prescribed persons are those in Schedule 1, first schedule. Yes. Okay, so we look at that. Thanks for that recommendation.
If I should move on to section 19(4)(b), the section refers to the obligation of a minister or prescribed person to refer a disclosure to another minister or prescribed person where they are not entitled to investigate the matter disclosed under the provisions of the Act. The provision does not, but we think should take into account circumstances where the minister or the prescribed person is also not entitled to investigate the matter disclosed under the provisions of any other applicable law. And it is suggested that section 19(4)(b) be amended to refer to the provisions of the Act or any other law that would be referenced. And there appears to be a drafting error in section 19(4), which I think
no,
CPC
what we'll do is to ask CPC to have a look at it.
Yes.
Because I'm not too sure I understand.
Okay.
Well, but have a look at it from a CPC.
I'm back to the margin. So yes, we agree.
Okay.
That would
and you were to assist us with...
yes.
19(4)(b).
It was what? 13?
15.
Which section were you
Section 15.
Yeah.
Right. So it's already limited in subsection 2 because this section only provides immunity for matters that are dealt with in accordance with this act.
So it's implied?
Yeah, it's not. It's more
That's
than
what I was thinking.
implied.
Thanks, CPC.
Yes.
All right. So unless there are any other comments, I would like to really... no.
That is already dealt with in the parish court legislation.
Yes. Oh, I didn't even realize. So what is being suggested?
We just think that there is, since this is a piece of legislation that is being reviewed, that it should be updated.
No, yeah, it's just updated. Right. In other words, this came about before the parish court was named, was changed. So that will be updated in the new revised legislation. But I want to thank you, both of you, Mrs. Walters and Ms. Lewis, but you still have an obligation to provide us with the additional information in relation to the reference, okay? So if you just pass it on to the Secretary for us, please, and I want to thank you for being with us, okay? Colleagues, I would suggest we put off the minutes until the next meeting. We have had a long morning, okay? So can I have a motion then? Let's wait on the chairman to give us a date, okay? Would like to thank the technical staff, CPC, law reform, and parliamentary attorneys, and thanks everyone for being here. Thank you, members, for being here. Can I have a motion? So moved? All right.
So moved.
All right, thanks everyone. Thanks, Minister Ford. I see you're no longer traveling, you're out of your vehicle now. Okay.
I am here, Minister Choke.
All right, take care, have a good day. Have a good rest of the day.
Okay. Good.
culture, niceness, heritage, laughter, and tons of fun. It's the broadcast of the inaugural PBCJ Watch Party, April 20 at 5 p.m., with a rebroadcast on Friday, April 25 at 6 p.m. Relive the joy of watching Lime Tree Lane and see the actors including Dorothy Cunningham, Miss Zella, Christopher Daly, Johnny, Silton Townsend, Mars Gussie, and Andrea Anderson, Tiny. Plus, watch the 3 winning films in the JCDC's short film contest: Shattered by Sabrina Thomas, Undertow by George Malcolm Walker, and She Saw by Shauna K. Wright. Be part of the interaction with the actors and the audience. Be part of the fun and games masterly woven together by preeminent broadcaster Faye Ellington. It's the broadcast of the inaugural PBCJ Watch Party, April 20 at 5 p.m. and April 25 at 6 p.m. Grab your popcorn, grab some friends, and have your own watch party.
The following is brought to you by the Office of the Prime Minister.
Jamaica is changing right before our very eyes. Across the island, billions are being invested into our road networks, from farm and community roads to major roads and highways. Dozens of communities across the length and breadth of Jamaica are receiving access to reliable potable water for the very first time. And thousands of Jamaicans have become homeowners thanks to the historic shifts in policies of the National Housing Trust, making it easier for Jamaicans to receive funding. Not to mention the record number of houses being built. Never dreamed you would own a home? No matter your circumstance, home ownership is possible for you, thanks to the government's new social housing program specially designed to meet the needs of poor Jamaicans at no cost to them. We are building Jamaica.
The proceeding was brought to you by the Office of the Prime Minister.
Diabetes is high glucose level in the bloodstream. In Jamaica, we have 236,200 people living with diabetes that are known. It's a chronic illness, therefore it's not curable, sad to say, but it can be controlled through proper monitoring such as dieting, exercise, medication, the checking of the glucose level, and consultation with your physician. It is our duty to give care to patients that are diabetic. Whether you're a member or non-member, you can see our consultations. We have a wide range of services that we offer to patients, such as diet plan, our diabetes education, also to teach patients about diabetes, how to monitor themselves and to manage diabetes, to check their blood glucose level and how to treat themselves. At the DHA, we have our Life for a Child program that's for patients 0 to 25. What we offer to them is free insulin, free Lancet, free blood sugar machine, also education and support group for them. You can call us at 927-6774 and you can speak with Nurse Nicorine Knight. She's a clinic coordinator and she will educate you and walk you through the step of what is to be done.
Today, we can report 2 consecutive years of reduction in major crimes and murders, with a significant reduction of almost 20% in murders for 2024.
Between January 2022 and January 2025, we have reduced murders by 51%, and January 2025 had the lowest monthly murder count since September 2014.
Our efforts have also resulted in the reduction of active gangs by 50%. We continue to increase firearm seizures, and in more communities, we are experiencing less violence. We will realize our vision of Jamaica as the place of choice to live, work, do business, raise families, and retire in peace and prosperity.
The proceeding was brought to you by the Office of the Prime Minister.
I'm Yara Nagoose, and you're watching PBCJ, the People's Station.
I am Natasha Burnett, and I've been having a great time at the Jamaica Blue Mountain Coffee Festival. So far, I've experienced quite some innovative products like spice jelly jam and a coffee syrup. But my favorite is the So Good Barista line over by P.A. Benjamin's. It's so good, like the flavor, the consistency, and I feel like it will become my favorite breakfast pairing.
We want to encourage a broadening of that appreciation of the value, indeed the depths and the lengths and the width of this elongated value chain that coffee has, and that we can in fact be wealthy through our coffee.
I'm just happy to be here for, I think this is my 3rd anniversary of coming to the Coffee Day, where Jamaica Blue Mountain Coffee is reigning. We're happy that tourists come here, Jamaicans come here, and have a wonderful day at Hope Gardens. If you haven't come here yet, come on down. It's a great time to be here.
Well, the Coffee Festival has been absolutely amazing in its 8th year, and it has grown so much. I feel so honored, so blessed, and just always excited to be a part of the Jamaica Blue Mountain Coffee Festival, because it is authentically Jamaican. It's authentically Jamaica land we love. It has been wonderful. I'm grateful. It has been exhilarating. The audience has been wonderful. The tourism enhancement fund, tourism linkages, everybody has been absolutely wonderful. Big ups to Jenny. I'm your Queen Diva, Miss Kitty. Big up to Jamaica. One love, out of many, one people, one coffee fest.
Hi, I'm Dr. Kerry Wallace, Executive Director of the Tourism Enhancement Fund, here at the Jamaica Blue Mountain Coffee Festival, the 8th staging. The first year we're doing it at Hope Gardens, and it's been a smashing success. So we think it's going to be our permanent venue for years to come. We're looking at the first Saturday in March every year, so you can put it in your calendars from now for next year's staging, which I'm sure will be much bigger and better. So thanks to all who have made today's staging a great success, and we look forward to more.
Ask yourself this question. Who don't say who know a bad man, Jennifer? Have you ever stopped to think what make a girl cheat? And have you ever searched you like how you do it? You need to check yourself before you start kiss your teeth, cause
you're not ready for this yet.
Wouldn't you wait from me? You want right. Hit the curb and I'll slip on a slide. After you, here's what I'm gonna do. Don't love you like I do. You need to know that.
And to my satisfaction, all the little things that you want me to, baby. You say you love me, baby, and we should be together. One day at a time. Baby, don't worry, it's gonna be
Jamaica, a one life we have. Don't let this be your story. Look out for yourself and others. Too many Jamaicans are dying on our roads. So, slow down. It's not worth the rush. Arrive alive. A message from the Office of the Prime Minister.
Let's face it, we don't always have perfect relationships with our mothers, stepmothers, or adoptive mothers, but sometimes, over time, these relationships heal. Enter the PBCJ's Me and My Mother Doing Better contest and win great prizes. 2 tickets to Basil Dawkins' hilarious play First Lady, featuring Dion Silvera, Dennis Titus, and Renee Williams at the Little Little Theatre. 2 tickets to the special Mother's Day fashion show by the Canadian Women's Club of Jamaica on Mother's Day at the AC Marriott Hotel. A professional makeover for your mother by Adolphus Makeup Artistry. Here's what you do. Record a 2-minute selfie video about how your relationship with your mother has healed over time. State your name in the video and, if you wish, your mother's name. Post the video on your Instagram page and tag PBCJ, or email your entry to communications@pbcjamaica.org. Entries close April 24. Winners will be announced on May 5. Let's celebrate mothers with the PBCJ Me and My Mother Doing Better contest. Enter now. It's going to be a bag of culture, niceness, heritage, laughter, and tons of fun. It's the broadcast of the inaugural PBCJ Watch Party, April 20 at 5 p.m. with a rebroadcast on Friday, April 25 at 6 p.m. Relive the joy of watching Lime Tree Lane and see the actors including Dorothy Cunningham, Miss Zella, Christopher Daly, Johnny, Silton Townsend, Mars Gussie, and Andrea Anderson, Tiny. Plus, watch the 3 winning films in the JCDC's short film contest: Shattered by Sabrina Thomas, Undertow by George Malcolm Walker, and She Saw by Shauna K. Wright. Be part of the interaction with the actors and the audience. Be part of the fun and games masterly woven together by preeminent broadcaster Faye Ellington. It's the broadcast of the inaugural PBCJ Watch Party, April 20 at 5 p.m. and April 25 at 6 p.m. Grab your popcorn, grab some friends, and have your own watch party.
What's going on? This is Cardinal Official live from Kingston, live from the Island Music Conference, and you are tuned in to PBCJ, okay?
It's Wednesday, April 23. In the headlines, AI Tutor now available to CXC students. In business news, BPO executive Yoni Epstein wants changes to labor laws. Regionally, in Belize, passenger on hijacked Tropic Air flight speaks out. And United Nations take action amid spike in armed violence in Haiti. In sports, World Athletics wants gender balance within national track and field federations. This is the news on PBC Jamaica. I'm Simone Absalom Gale. Students preparing for the CXC examinations now have access to additional academic support through the EduHub Smart Study app. The app is equipped with practice tests and mock exams. The details were shared at a recent JIS think tank. CEO of EduHub Company Limited, Davia Brian Campbell, says the app is integrated with artificial intelligence technology to facilitate personalized learning and provides analytics to track students' progress. She says it's available on Google Play Store and iOS, and over 1,000 downloads have been recorded.
The feedback from the students have been good in terms of what it is that it does for them in preparing them for the exam currently. Because CXC is actually, it has started and it will ramp up in May, and so our students are in preparation mode now, so it's a good time for them to have access to it.
Mrs. Brian Campbell also notes the inclusivity of the app with its text-to-speech feature.
Our text-to-speech feature allows for students who are unable to type or to read very well to be able to go ahead and use the voice note and text whatever their response is, whatever the question is that they have. You can always use the voice recording and have it record their voices and search for the questions. And for those who, you can also read the questions to them as well. So we ensure that, whatever it is that we're doing as best as we can for it to be adaptable and accessible to our students, we try to do that.
She says it's available to all high school students.
All of the subjects are there, as well as all the topics for the students who are doing CXC. So every subject that the students do, both in CAPE and in CSEC, are in the app, and it is also available. And even if they are in different, say for example, in grade 7,